Mr. Clerk, will you call the next case, please?
Yes, Your Honor. Elizabeth Killen v. Linda M. Boardman.
Are we short an attorney on this case?
She's pro se. She's pro se.
Yes, ma'am. Let's see, are we seated in proper seating? You are for the appellant, appellee?
Appellant, Your Honor.
Appellant.
Appellant.
And for the appellee? Okay. The way we proceed in these matters, the appellant would proceed first. Each party has 15 minutes per side. The appellant, however, has the option of reserving some of that time for rebuttal. That means after they present their case, then you would have the opportunity to present yours, and the appellant would have, if they serve reserve rebuttal, will be able to rebut or to make statements in rebuttal of what you presented, okay? Okay, then let us proceed then for the appellant.
Your Honor, as a brief housekeeping matter, I didn't address this in motion. However, I would like to just go ahead and put onto the record that the reply brief from Ms. Killen didn't necessarily meet the scope of review. She did try to introduce some things that weren't necessarily appropriate for the appellate court, so I would ask that you don't consider her reply brief in your consideration for the court. That being said, I do want her to have the opportunity to argue and present something to the court. However, if you could please instruct her that anything that she does present to the court be limited to the appellate review, not necessarily any new information or new facts, Your Honors.
We will review what we have before us, and
Yes,
we'll
Your Honor.
make those decisions.
Yes, Your Honor.
Do you have any reservation of time for rebuttal?
Yes, Your Honor. If I could reserve 5 minutes for rebuttal, Your Honor. I don't believe I'll use the entire time, however.
You may proceed with your presentation.
May it please the courts, Your Honor, I'm Joe Cooper. I'm here representing the appellant in this matter. This is Ms. Elizabeth Boardman, or excuse me, Ms. Linda Boardman, excuse me. Your Honors, this case is a pretty simple one, in my opinion. I think it just really revolves around one simple sentence in the beginning of a restrictive covenant. The standard for review here is going to be de novo for these questions of law that we're determining what is the interpretation of the restrictive covenant and abuse of discretion in applying any kind of incorrect legal standards, which we see, and I highlighted in my brief for the Lutzak matter. I first want to start talking about how there is an ambiguity. That's something that was brought up with the trial court, that there is no ambiguity and that one means one. I think that de facto there's an ambiguity here because me as an attorney, I can take a look at this and say there's another meaning to this. There's another way that we can interpret one tract or one residence on one tract. And exactly the example that we're bringing up and exactly the situation Ms. Boardman's in is that if the property is subdivided, it still can fit under that restriction of one tract or one resident on one tract, since there are two distinct tracts now. And tract and law are kind of used interchangeably. The law's Black Dictionary uses them also pretty interchangeably as well, so I don't think there's necessarily an issue in determining, well, is it a lot or a tract? Those are congruent words. So I believe that ambiguity does exist, and kind of coming to a conclusion on this and how to rationalize this best, I think the best argument to make is kind of what I like to call the time travel analogy. If we had a time machine, we can go back and we could go to the developer in this case and say, developer, what did you mean when you put one tract or one residential and farming purposes and only one residence on one tract, I think he could easily say, well, I'll put the farming restriction on there because I didn't want the people to get in trouble for growing corn in their yard, and I put one house on one tract because I didn't want apartment buildings, I didn't want duplexes, I just want one home on one tract. If you asked him, hey, do you think it'd be okay to subdivide? He'd say, well, he could potentially say, well, I didn't include it in there. And that's exactly what the Supreme Court demands here, is that the express terms of the restrictive covenant are upheld. And if there is an alternative argument as to a reasonable expression of those terms, and that needs to be followed. Construction against restrictive covenants requires restrictive covenants to be read against the drafter. Alternative construction that conform with the clearly expressed intentions manifested in the restrictions themselves, while still giving the terms used in the restrictions their fair and reasonable meaning, and decline to extend them beyond their clearly expressed scope, is what this court requires and what the Supreme Court requires when we're looking at these restrictive covenants. And if a term or if a new construction advances the unrestricted use of the property, resolves ambiguities in the restrictions against the party who drafted them, and resolves all doubt concerning a covenant's applicability against applying the covenant, then we have to apply the new construction. And that's exactly what we're asking you to do in this case, Your Honors. Our construction of this term says that we should be able to subdivide the property and introduce a new property onto the newly subdivided tract. It would still conform to the same restrictive covenants that it'd be held under from the beginning. And I think it'd be a huge concession if the original restrictive covenant said one original tract, we wouldn't be here today. If it said on tract 19, I don't think we'd be, lot 19, I don't think we'd be here today.
What if your client or anybody in the subdivision decided to subdivide the tract into 5 smaller tracts?
Well, there's obviously going to be certain restrictions and zoning from the city, county, things like that. That could restrict
Assuming they
those.
allowed it and
Assuming they would allow it, I would believe that that's something that would be permissible if it's not expressly, if it wasn't expressly prohibited through the restrictive covenant. Otherwise, it's a little too late to kind of put one of those things in there. That being said, I think that does take it a little bit to the extreme, and I definitely understand the argument. I think that's what the trial court was thinking as well when it made its decision. However, simply put, these restrictive covenants are supposed to be construed or are negatively construed, and they're read against the drafter, and they're also against public policy. We don't want to have these restrictive covenants burdening the land for as much time as it takes for them to eventually have some type of resolution to the restrictive covenant. But this is one indeed that would run with the land forever, or at least that's what we would concede. I apologize, I went a little bit off course. However, one of the other things that I did want to mention is the trial court brings up LUTSAC, something that we weren't necessarily given an opportunity to take a look at beforehand, although it is good law and it does somewhat come into play. The LUTSAC case specifically, and Judge Dugan's decision in the trial court, had to do with an implied restrictive covenant. And looking at the LUTSAC case, and there was a case, I don't have a cite to it, it's a very recent case, I only saw about it this morning. These implied restrictive covenants are basically when the developer gives some kind of reassurance that there is some type of development scheme, and then that buyer relies on that assurance in having some type of, let's say, for example, a developer says, well, we're not going to have any pools in the place that's going to be in the restrictive covenants, and the buyer buys it thinking there's not going to be any above-ground pools, and then lo and behold, next thing they know, someone does an above-ground pool. That person may be able to file suit and say, well, I relied on the developer who said we weren't going to have above-ground pools in the neighborhood. Ms. Killen, in this case, can't necessarily do that. She didn't buy from the developer. So I don't believe that LUTSAC would apply in this case. I don't think the standard would necessarily apply, and for that reason, I think the court applied an incorrect legal standard in coming to its conclusions. When speaking more about the ambiguity, though, I really like to think about this time machine analogy, because if we could go back and ask him, well, why did you do this? He might be able to give us a different answer, and that answer could conform with our construction and reading of the restrictive covenants. We'd ask that you go ahead and reverse the trial court's decision in this matter and remand if necessary for further instruction, and I'll reserve my time. Thank you.
Okay, thank you. Yes, ma'am.
I have to disagree with Mr. Cooper. To me, one means one. One lot means one lot. And I don't think that the deed restrictions are ambiguous, because it states on there you can't raise pork and chickens and things that would upset your neighbors. You can obviously have livestock on the property. But I purchased the property over 20 years ago. I was given a set of deed restrictions. And I've complied with those. Mrs. Boardman also got those restrictions. The deed restrictions clearly say one dwelling per lot. Mrs. Boardman via text informed me that the deed restrictions, when I asked her about this, she informed me that the deed restrictions expired. I explained to her in 2 different texts that, show me where this happened, because I had actually looked into this and found out they did never expire. So what I feel is that Mrs. Boardman decided to circumvent the rules when she bought the house, split it in 2, and then make 2 lots and 2 dwellings. Well, that's fine, except the deed restrictions say 1 lot, 1 dwelling. So the bottom line is the deed restrictions to me prohibit this, and she was aware of this, and she continued to build anyway.
Thank you. Yes, sir, your rebuttal.
Justices, on rebuttal, I'd simply like to just bring up the fact that these restrictive covenants are against public policy. They're supposed to be viewed in the light most favorable to the or against the party drafting them. Simply put, the restrictive covenant just falls flat on what it needed to do to be able to stop someone from doing what Ms. Boardman would like to do to her property. Like I said previously, if this would say 1 original lot or lot 19, I think this would be a different story. However, as we saw with Benton, Jones and England, these cases where that small distinction is made clear, lot 19 or lot 19, that distinction is made, that's where that distinction lies, and this restrictive covenant just does not meet muster under Turnley in order for it to have the effect that Ms. Boardman or Ms. Killen would like. For that reason, y'all must overturn the trial court. Thank you, Your Honors.
No questions. I hear no questions then. I want to thank you both for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and ruling within a reasonable period of time. Okay. Both parties may be dismissed.